Aloha mai kako, and good morning, everyone. It is now 10:15 a.m., and I'm calling to order the continued meeting of July 15th, 2026 of the State Land Use Commission. This is a hybrid meeting being held in person at the ILWU Local 142 office, the Maui Division Conference Room at 896 Lower Main Street, Wailuku, Hawaii 96793, and with virtual participation via Zoom. This meeting is open to the public. Please be advised that this meeting is being recorded via Zoom, and the recording will be posted to YouTube and used for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. And if you do not wish to be part of the public record, you should exit this meeting now. For those attending via Zoom, please note that the Q&A feature will only be used for signing up for public testimony, and all other communications through Zoom will not be monitored or made part of the meeting record. Written communications can be emailed to the Land Use Commission office at dbedt.luc.web@hawaii.gov. For all meeting participants, please speak slowly, clearly, and directly into your microphone. Before speaking, please state your name to identify yourself for the record. I want to also share with all participants that we will be taking breaks from time to time, roughly every hour. For commissioners participating remotely, please state your location, whether anyone over the age of 18 is present with you. I don't believe we have anyone like that today. Aloha, everyone. My name is Brian Lee, and I will be serving as the LUC chair today. There are 7 seated commissioners, and joining me today is Commissioner Jason Bradshaw from Oahu. By the way, welcome, Jason. This is your first really full meeting, and I appreciate your service. Also with us is Second Vice Chair Mel Kōʻele from Oahu, First Vice Chair Kuike Kamakia Ohelo from Oahu, and Commissioner Bruce Uu from Maui, Commissioner Miles Miyasato from the Big Island, and recused today is Commissioner Ken Hayashida from Oahu. Also in attendance today is the Land Use Commission Executive Officer, Mr. Daniel Ordenker, the LUC Chief Planner Scott Derrickson, LUC Staff Planner Martina Segura, LUC Chief Clerk Ariana Kwan, and the Madam Deputy Attorney General, Ms. Miranda Steed. Again, court reporting transcriptions will be done from this Zoom recording. Agenda item number 2 is to consider the Pūlama Lanai petition for Land Use District Boundary Amendment, or DBA, of approximately 95.844 acres of the petition area from the Agricultural District and approximately 74.381 acres of the petition area from the Rural District to the Urban District to facilitate alignment with the underlying community plan designations and proposed county zoning and project district updates to the area. Will the parties please identify themselves for the record? Petitioner, will you please identify yourself for the record?
Yes, Chair. Good morning. And good morning, members. Cal Chipchase and Chris Gooden for the petitioner.
Thank you. County of Maui Planning Department.
Thank you, Chair, members of the Commission. Michael Hopper, Deputy Corporation Counsel, representing the Maui County Department of Planning. With me are Planning Director Jackie Takakura, Planner Danny Diaz, and Planner Kurt Wallenhop will be joining us later. Thank you.
Thank you. State Office of Planning and Sustainable Development.
Good morning, Allison Kato, Deputy Attorney General. On behalf of the Office of Planning and Sustainable Development, Director by Alice Evans is here with me today. Thank you.
Thank you. Thank you, Director. All right, Mr. Chipchase, have you reviewed Hawaii Administrative Rules, Section 15-15-45.1 regarding the reimbursement of hearing expenses?
Yes, Chair.
All right. So in accordance with Hawaii Revised Statutes, Section 84-14, commissioners are not allowed to take any official action affecting a business in which they or a member of their family has a financial interest. They must therefore recuse themselves from this matter if there's any benefit, monetary or otherwise, to themselves or members of their family. Also, in accordance with legal ethical standards, commissioners should disclose any relationship, business or social or otherwise that they may have with the petitioner or its representatives or any of the other parties to this proceeding that may give rise to an allegation of bias or impropriety. Do any of the commissioners have any conflicts of interest or disclosures they wish to make? Okay, seeing none, thank you very much. As a reminder, commissioners are prohibited from engaging in ex parte communications regarding pending or future docket matters pursuant to HAR Section 15-15-62, and this includes off-the-record discussions with parties, attorneys, applicants, or interested persons during recesses or breaks in these proceedings. To ensure transparency, fairness, and public trust in the Commission's process, all discussions relating to docket matters must occur on the record during the public meeting. Commissioners and parties are respectfully asked to avoid any off-the-record communication concerning matters before the Commission. Let me briefly now explain the procedures for today. First, the Commission will acknowledge any written testimony that has been submitted for the record. Next, we'll open the floor for members of the public who wish to provide oral testimony. And following the public testimony, the LUC staff planner will present the staff's report for this docket. The petitioner will then present its case in support of the petition. And after the petitioner's presentation, the County Planning Department and the Office of Planning and Sustainable Development will each present their respective positions. As each party presents its witnesses, the hearing will proceed in the following order. The party will present its witnesses and any supporting evidence. The remaining parties will have an opportunity to cross-examine the witness, and the commissioners may then ask questions of the witness. The presenting party may conduct redirect examination if necessary. After each party has completed the presentation of its case, the commissioners will have an opportunity to ask any additional questions of the parties before the next party begins its presentation. Once all parties have completed their presentations, the petitioner may present any rebuttal evidence permitted by the Commission, and the parties will then have an opportunity to present their closing arguments. Before closing the evidentiary hearing, we will reopen the floor for any additional public testimony that is new and relevant to the matters presented during today's hearing. Finally, we will close the evidentiary portion of this proceeding, and the Commission will establish a schedule for the parties' post-hearing submissions and the next hearing date. And we would like to once again remind all participants to speak slowly, clearly, and directly into their microphones. And before speaking, please state your name and identify yourself for the record. This will ensure that our transcriber can produce an accurate transcript of the proceedings. Are there any questions about our procedures for today? Okay. As stated on today's agenda, please be informed that the relevant documents and filing dates pertaining to this matter can be accessed on the LUC website at luc.hawaii.gov/A26-812. All right, we'll now recognize any written public testimony submitted on this matter. Ms. Kwan, has there been any written testimony submitted on this matter?
Yes, Mr. Chair, we received 7 written testimonies that have all been posted to the website.
Thank you, Ms. Kwan. Are there any members of the public that wish to provide verbal testimony on this matter?
Yes, Mr. Chair, so far we have 1 in the queue, and I will promote her now.
Thank you.
Lealoha, may you turn on your camera and microphone, please, for a mic check?
Aloha, can you hear me?
Yes, kind of faint, but we can hear you. Okay. Let's see, Ms. Makuanani, will you please state your full name and zip code for the record?
I am Lealoha Makuanani. The zip code is 96716.
Thank you. May I swear you in now? Do you swear or affirm that the testimony that you're about to give is the truth?
Yes.
Thank you. You will have 2 minutes for your testimony. Please
Okay.
proceed.
Like I said, my name's Lealohama Kuanani. I'm testifying on behalf of the Office of Hawaiian Affairs. OHA provided written comments and recommended conditions for approval of the petition. So largely I'm standing on the written testimony that we submitted, but I'm here in case there are any questions and would like to provide a brief summary of our main concerns. We highlight first regarding historic and cultural resources that the petition appeared to misstate the locations that were surveyed in the archaeological field inspection as outside of the current petition area, when actually the identified historic sites and some of the newly identified ones, including the historic ranch houses, are on portions included in the petition area, according to that literature review and field inspection report. There was also at least 83 acres of land that had no field inspection done that falls within the petition area. So we're basically just asking that the record accurately reflects that information, and that further compliance with HRS 6E review happens if there's further development as that moves forward. And we also highlighted that the assessment of cultural resources and practices particularly relied on historical documentation from the past, and all interviews that were included happened at least a decade prior to now. So we're recommending a supplemental cultural consultation and updated Kapa'akai analysis that would include more current cultural consultation. And then regarding water resources, OHA also had concerns about the use of potential potable water for golf course irrigation or park irrigation within the petition area. It includes former golf course lands, and the related county legislation that's cited in the petition to amend the project district at the county level could also allow continued use of high-level aquifer groundwater for golf course or park irrigation. It was given that Lanai has limited potable water resources and a long-standing policy from both prior LUC conditions and at the county regulations, we're recommending that any approval would prohibit the use of Lanai's groundwater aquifer for golf course or park irrigation within the petition area, and require alternative non-potable water sources instead. And then lastly, we just have some concerns about the housing impacts that are not fully addressed, in our opinion, in the petition, which stated that the land use realignment would not impact housing needs. But the FEA's socioeconomic report projects substantial increases in resort-supported jobs and housing demands on Lanai. And that's going from 34 homes for resort workers to 506 homes for resort workers, which is quite an increase to not disclose in the body of the petition related to those housing impacts. So we just wanted to recommend requiring clear disclosure of impacts and consider a housing impact mitigation condition. Mahalo for your time. That's all I have. But again, I'm available for questions.
Thank you, Ms. Makuanani. Commissioners, do you have any questions for the testifier?
I got a question.
Commissioner Kōʻele.
If you okay, oh, you can't have to show them basketball.
Well, it's still on here. You can keep talking.
What am I talking to? Is she on? Yeah, she's on. Hi, Leah, I got a question. You know, on your page 5 on your testimony, you're asking the LUC to require supplemental cultural consultation and updated Kapa'akai analysis.
Yes.
Didn't they meet the requirement?
So in our testimony, it explains that the interviews that were included are from about a decade ago, is the earliest ones. So it's based on mostly historical information, and any in-person interviews that happened are actually just from historical records. So there hasn't been within the last decade or so any current interviews or cultural consultation specifically with anybody from that area. And so our concern is just whether what is included is sufficient enough to know whether there are any current practices or activities or concerns from current cultural practitioners or otherwise in that particular area, because the information included is historical, and then there's good information in there about the historical resources. But our concern is we typically comment this way across the board, that if there haven't been recent interviews with people from a certain area, that we always recommend that there be more done to get more recent information about current practices that may be occurring.
I got lost, but it seemed like they did meet the requirement. In your explanation, it seemed like, I got more confused, but so did they meet the requirement in meeting the Kapakai analysis? And you're asking the LUC, you're asking the commissioners that they provide more information? I'm sorry, man.
No, yeah, I hear what your question is. From our opinion, to meet the requirements of Kapa'akai analysis, which is identifying the scope of the cultural resources or practices that happen in an area, you have to have some more recent information. It cannot be all historical, and that has to do with sometimes, if there's continuing use, maybe the old stuff can provide some of that information, but not always. So our stance is typically that if you're doing Kapa'akai and trying to understand if there are any traditional or cultural practices that are ongoing, which is what Kapa'akai is about also, is the ongoing practices that may occur that could be impacted by projects. That's not to say that we have a stance on whether there actually are, but for it to be sufficient to meet a Kapa'akai, that there should be at least attempts, some sort of documented attempts to show that there was outreach to consult with people currently. And usually within the past few years or so, 5 years even is okay, but most of these interviews happened, the most recent, I believe in the reports, was 2007, which is actually a couple of decades.
Yeah.
All right. Thanks, Julia.
Yeah.
Thank you, Ryan.
Thank you, Commissioner Kahele. Any further questions from commissioners? I think this will be discussed later some more, but yes, thank you for your testimony, Ms. Makoinani.
No.
All right. Council, Mr. Chipchase, please describe the exhibits which you wish to have admitted to the record.
Yes, Chair, shall do. The exhibits are included with the petition that we filed. I think they're described in the list accompanying that. And so we ask that all of the exhibits associated with the petition be admitted into evidence.
Okay. Any objections from the parties?
No, Chair.
All right. State?
No.
Thank you. Hearing none, petitioner's exhibits are admitted to the record. County, do you have any exhibits you wish to have admitted into the record?
Yes, thank you, Chair. We have two exhibits, exhibits 1 and 2, identified on the county's exhibit list. We would move that they be accepted at this time.
Thank you. Are there any objections from the parties to the acceptance of the county's exhibits to the records?
No objections by petitioners, Chair.
Thank you. State, OPSD?
No objections.
Thank you. Commissioners? Okay, seeing none, the County of Maui's exhibits are admitted into the record. Office of Planning and State Development, Sustainable Development, Office of Planning and Sustainable Development. Do you have any exhibits you wish to have admitted into the record?
Yep, Alison Kato, yes, Chair. We have exhibits numbers 1 through 8 listed on our list of exhibits. Additionally, today, both of the witnesses that are on our list of witnesses are unable to attend. And so instead, we are asking that we can substitute Mary Alice Evans, Director of OPSD.
Okay, yes, thank you. Oh, all right. I'm gonna ask the petitioner, do you have any objections to that?
No objections from petitioner, Chair.
Okay, County of Maui, do you have any objections?
No, thank you, Chair.
Thank you. Commissioners, any objections? Okay, seeing none, your exhibits are admitted into the record. Thank you. All right, we'll now call on Mr. Scott Derrickson, LUC Staff Chief Planner, to please summarize the staff's report.
Aloha kako. Scott Derrickson, Chief Planner, State Land Use Commission. So the Land Use Commission is considering Pūlama Lanai's petition to reclassify approximately 170.225 acres in Kōʻele from agricultural and rural to the urban district. The purpose of the July 15th, or today's date, the July 29th evidentiary hearing, is only to receive evidence, not to deliberate or decide. And because we have a new commissioner, and for the most part, the other commissioners have not gone through a district boundary amendment. We've only dealt with mostly motions and DRs and special permits. So I just want to remind you, here are some of the key decision-making criteria that commissioners must rely on. And the petitioner needs to provide clear preponderance of the evidence and address statutory and rule-based criteria. These include the commission needs to determine whether the land meets the applicable urban criteria, which includes city-like uses, services, proximity to employment and services, adequate physical conditions, contiguity with existing urban areas, consistency with state and county plans, and avoidance of spot development. These are found in Hawaii Revised Statutes, HRS Chapter 205-2, and Hawaii Administrative Rules, HAR 15-15-18, Urban Standards. In addition to that, there are specific criteria in Hawaii Revised Statutes 205-17 and Administrative Rules 15-15-77B as in Bravo, for the commissions to consider consistency with the Hawaii state plans, impacts on natural, cultural, historic, agricultural, economic resources, public service and infrastructure capacity, housing considerations, any commitments made by the petitioner, agricultural land standards, and the county general and community plans. In addition, there's also the coastal zone management objectives found in HRS Chapter 205A-2. Summarizing the petitioner's case, they have indicated that they believe the reclassification enables full implementation of their Kōʻele project, the Kōʻele project district, which includes hotel expansion, spa hales, villas, resort commercial uses, and park development. They've indicated that they believe the existing uses will continue with no impact on housing obligations. They've conducted environmental review, final environmental assessment, which indicated no significant impacts and included mitigation with best management practices. The project lies outside sea level rise hazards. Climate analysis shows minimal net greenhouse gas emissions. And they assert strong consistency with the state plan, Maui County General Plan, and the Lanai Community Plan. They've indicated economic benefits would include construction jobs and increased state and county revenues. They've conducted a kai analysis, which they found no Native Hawaiian traditional customary practices would be affected. OPSD provided us a position statement where they provided conditional support. They do request certain mitigation measures, and also a request for a development timetable for the incremental districting consideration. They asked to require SHPD, State Historic Preservation Division, consultation for any future ground disturbance and confirmation of prior SHPD requests for information. They did conclude that the petition generally meets state plan and urban district boundary standards. The county's position was to support reclassification. They did identify 2 historic structures, and they acknowledged petitioners' plans to relocate those with SHPD consultation. And they did indicate they might refine its position as more evidence is provided. Staff, in its review, indicated that the petition demonstrates consistency with state and county plans. It met all the urban district standards that I identified. Shows adequate public service capacity. It provides for mitigation for environmental and cultural impacts, and it did include a Kapa'akai analysis that found a support for no cultural impact. The staff recommends approval with conditions consistent with mitigation measures proposed in the final environmental assessment, in OPSD's requests, as well as the county's requests. I will note that you just heard the Office of Hawaiian Affairs did provide public testimony, and they did provide written analysis with a number of questions and issues that you guys will have to address. I will point out as well that Kapa'akai analysis is not something necessarily that's required of the petitioner. It is a requirement for the commission itself to take. It's your job to do a Kapa'akai analysis based on information provided by the petitioner and any other parties. So if you believe that there's additional information that needs to be provided, that needs to be addressed by the petitioner. With that, I will conclude the staff report for now.
Thank you, Mr. Derrickson. Commissioners, do you have any questions for Mr. Derrickson? Okay, I'm going to ask Mr. Derrickson, can you respond to Ms. Makuanani's point about the Kapa'akai analysis requiring more current, recent analysis?
I can respond. I'm going to also ask the Deputy AG to make sure that I respond consistent with her understanding as well. But it is, again, it's the commission's responsibility to ascertain whether the information that's provided is sufficient to make findings that are consistent with the state Supreme Court's 3 tests. So in terms of whether the information is old or stale, I do think that you need to probe the petitioner and make sure that you are comfortable in saying that the information is sufficient, even though it may be old or outdated. Otherwise, you do need to require supplemental information to be provided before you can make a decision.
Okay, thank you, Mr. Derrickson. I think this will come up again, but commissioners, again, are there any questions for Mr. Derrickson? Okay, seeing none, thank you for your report. Mr. Chip Chase, to assist the commission with today's schedule, could you please provide an estimate of how long you expect your presentation to take? And please include the number of witnesses you plan to call, the approximate time for each witness, and your total estimated presentation time.
Yes, Chair, I will. We estimate our total presentation time at about 30 minutes. I plan to call 3 witnesses. Their time is more or less evenly divided. Mr. Matsumoto will have probably the shortest presentation. Dr. Dancer will probably have the longest presentation, and we'll conclude with Dr. Watson, who will discuss historical and cultural resources.
Okay, thank you. You may begin.
Thank you. Chair, Commissioners, as the chair's summary explained and as the staff report indicates, we're here for consideration of a district boundary amendment related to the Kōʻele project district. The total area, including the rural and agricultural lands, is about 170 acres. And as you also heard in those introductory remarks and in the staff's summary, this district boundary amendment is about alignment. The consideration of the uses for these areas has already gone through an extensive county process that began with the environmental assessment and continued through the amendment to the community plan. And so the community plan for Maui County has already been amended to contemplate these areas and the uses that we have proposed. In processing that community plan amendment, the petitioner went to the Lanai Planning Commission, received approval there, and went through a full county council process, including committee hearings and 2 full council readings to amend that community plan. The process, the way it's currently organized, then requires us to come to the LUC to align the state district boundaries with that community plan. And that's why we're here today. We're not at the beginning of the process, as sometimes you might see in a district boundary amendment. We're toward the end of the process. The last step is to go back to the county council to then conform the zoning to what has already been approved through the community plan, and then, if the commission agrees, through the district boundary amendment. And so we ping pong back and forth between the state and the county in order to complete the amendment of the land use districts for this area. It's a multi-year process, and as you'll see in the discussions with Mr. Matsumoto and with Dr. Dansel, community engagement on this process began 8 or 9 years ago, and we have probably the rest of this year at least to complete the process. So it's not anything that happens overnight or in a vacuum or without a lot of public interaction and public engagement, and you'll hear about some of that today. The other point that I wanted to emphasize, and it was mentioned in the staff report, but is that the petition comes before the commission widely supported. Not only has it received support from the Lanai Planning Commission and from the Maui County Council, but as you see in the submissions to the commission, the county is in support of the petition with conditions. OPSD is in support of the petition with conditions, including additional conditions that were proposed today and to which we've agreed on specific language. And I'll put the conditions up on the screen so the commission understands what has been proposed and what we've agreed to. One of those deals with water resources for landscaping and irrigation within the petition area. There are some important things to note, that the existing golf courses outside of the petition area and those sorts of things that really wouldn't be relevant in the consideration of OHA's comments on those points. But within the petition area, we've agreed to a condition with OPSD that I think addresses those relevant concerns. And then lastly, as Mr. Derrickson commented, staff is in support of the petition as long as it incorporates the conditions that OPSD and the county have expressed and that we've agreed to. And so I'm hopeful that through our presentation today and through the submission of the documents that we've put into evidence, we can assure the commission that this is a petition that meets all of those standards that Mr. Derrickson articulated, and I'll comment on them at the end, that is supported by the relevant agencies that look at, are tasked with reviewing and commenting on the petition, and that just simply completes the state process of alignment with what has already been approved through the community plan. To get there, I'll start with my first witness. I'll call Kurt Matsumoto, who's seated next to me. Mr. Chair.
Thank you, Mr. Chip Chase. Mr. Matsumoto, will you please state your name for the record?
Chair, my name is Kurt Matsumoto. I am the president of Pūlama Lanai.
Thank you. Mr. Matsumoto, do you swear that the testimony that you're about to give is the truth?
I do.
Please proceed.
If it's all right, Mr. Matsumoto, I'm going to get uncomfortably close to you so that we can share a microphone. All right. Kurt, would you please briefly describe your responsibilities at Pūlama Lanai?
In my role, I lead in my role as president, I lead a management team in carrying out Pūlama Lanai's work across the island. Our focus is to preserve and enhance the quality of life on Lanai by working with the community on long-term solutions in areas such as housing, conservation, energy, education, cultural preservation, and sustainable economic activity.
And Kurt, how long have you been with Pūlama Lanai?
I've been with Pūlama Lanai since the beginning in 2012.
And for way of background or by way of background, what did you do before you joined Pūlama Lanai?
So before Pūlama Lanai, I actually worked for the prior landowner for approximately 10 years. During that time, I helped to open the Manali Bay Hotel and manage the Lodge at Kōʻele and both golf courses on Lanai. I later managed resort operations on Hawaii Island at Manalani Bay Resort and also on Kauai at Kukui'ula Resort.
And so, Kurt, today we're here talking about the district boundary amendment for the Kōʻele project. And I'd like to start broadly with Pūlama Lanai's vision for the island and this district.
Pūlama Lanai's vision for Lanai is to be a self-sustaining and vibrant community. We believe that requires taking a long-term view, investing in infrastructure, protecting our natural and cultural resources, supporting housing and community needs, and creating economic opportunities that are appropriate for Lanai. We try to look at all of these things together because they are all connected.
And help us understand then how the changes requested in this petition, this alignment with the community plan, fit within Pūlama's broader vision.
This petition is one part of a larger effort. Responsible land use is essential to achieving that vision, and we believe it's important that our planning documents and land use designations accurately reflect both existing conditions and the community's long-term objectives. This petition helps bring those into alignment while supporting a balanced approach to conservation, community well-being, and economic opportunity.
Continuing sort of our broader look at things, what efforts over the years has Pūlama Lanai made to align the Kōʻele district with its vision for the island?
Yeah, this has been a multi-year effort. Over time, we've made a number of changes at Kōʻele, including the closing the former golf course, repositioning the hotel, the Sensei Lanai, introducing uses such as the adventure park. Those decisions reflected an evolution on how Kōʻele is used today and align with the direction established in the approved community plans.
So Kurt, is it fair to say that the petition and indeed all these changes to Kōʻele through the process that we've been through really weren't the first steps in aligning Kōʻele with Pūlama Lanai's vision for the island?
Yeah, that's correct. So we've been working on this since 2017. Over that time, there was extensive community engagement, environmental review, and review through Maui County before the petition came before this commission. Dr. Danso will walk through that history in more detail, but this has been a long and deliberate process.
And so I mentioned in my comments, Kurt, that the intent of the district boundary amendment is to align the state land use designations with the county council's approval of the community plan. Can you help us understand in what ways the council's changes to the community plan have affected the Kōʻele district?
The changes that were approved reduced the intensity of the land use within the Kōʻele project district. The amended plan reduces overall acreage and density. It reduces golf course acreage, increases park land and open space, and significantly reduce resort residential development. The net result is less intensive land use pattern at Kōʻele.
And so can you tell us how then this district boundary amendment would align the state land use districts with that community plan?
Yes, this petition includes a number of important housekeeping items that help align state land use boundary, county zoning, project district maps, and existing uses within the Kōʻele project district. The goal is to bring those land use documents into consistency with one another and the approved community plan. This is fundamentally an alignment in effort to ensure our planning documents accurately reflect the land use pattern that's evolved over time.
And as part of the alignment, the district boundary amendment of the community plan, I understand that Pūlama Lanai will be relocating two historic structures, homes that are within the petition area. Can you tell us a little bit about those structures and Pūlama Lanai's commitment?
Yes, well, they're identified in the planning documents as structures C and D. Many residents, including myself, know them as two ranch homes associated with Lanai's ranching history. We also know them as the Richardson family homes. These structures have been relocated several times and have been used for different purposes over the years. And Dr. Watson will discuss the history of the homes in more detail during her presentation. Throughout this process, we listen to residents through community meetings, subgroup discussions, individual conversations, and public testimony. Beginning, we consistently committed to relocate and preserve the homes and honor the history of Lanai ranching through the establishment of a museum.
And I understand that plans aren't finalized at this point, but what is your expectation for those structures?
We haven't finalized plans or location, but we continue to discuss it with people in the community. Over time, there have been differing views about where the houses should be located, including locations both Mauka and Makai of the Keamoku Highway. Because this is important to many residents, we'll continue those discussions as we move forward. And while the location and design remain under discussion, our commitment to the homes has never changed.
And so if I can just ask you to emphasize that last point, is it accurate to say that however the plans evolve, the structures will be preserved?
Yes, the structures will be preserved. We'll relocate the structures, preserve the homes, and use them to help honor the legacy of Lanai Ranch through the establishment of a public museum.
Kurt, at the beginning of our hearing, we reviewed some additional conditions proposed by OPSD. I understand Pūlama Lanai had already committed to the previous conditions that OPSD had approved. Is that correct?
That's correct.
And with respect to the 4 new conditions, one of which involves certain limitations on water use related to landscaping. I understand we've had an opportunity to work with OPSD on the language of that condition, and that Pūlama Lanai has committed to that condition as revised and to the other conditions that were proposed today by OPSD. Is that correct?
That's correct.
Thank you, Kurt. I have no further questions. Thank you, Chair.
All right, thank you, Mr. Chip Chase. County, is there any cross-examination of this witness?
No questions, Chair.
Thank you. OPSD.
No questions, thank you.
Commissioners, do you have any questions for this witness? Okay, I'm going to go with Commissioner Wu and then Commissioner Kōʻele.
Good morning. Just wanted clarity on the community plan change. Who decided to create the change? Was it Lanai company that decided to make the community plan change? Those Lanai company led that charge.
Pūlama Lanai.
Pūlama Lanai.
Yes, we submitted an application for the community plan amendment.
Okay, thank you.
Commissioner Kōʻele.
Oh, yeah, man. Thanks, yeah. You know, I got a question. On the aquifer, are you going to be able to provide and have enough water for the residents with the this new addition that you're putting up and be able to provide enough water where the aquifer going to be sustainable?
Yeah, Commissioner. So I think that's a great question. When you look at the total change that we're asking for, um, the addition or the expansion of the hotel is a very small component compared to the lowering of the intensity of the land use that we are also requesting. So, for example, taking the golf course out of play and changing the zoning to park so that it can never be turned back into a golf course, that's a significant reduction in the amount of water that can be used. In addition to that, we're also including a significant reduction in the entitlement for resort home development in that district. And so all this combined far outweighs the addition that we're requesting for the additional 11 acres to be zoned as hotel.
So you're taking away from Peter and giving to Paul. Yeah.
We're actually giving Peter plenty more than
What Paul had.
we're going to ask for Paul.
All right, thank you. I was just curious. Thanks.
All right, thank you, commissioners. Any further questions for Mr. Matsumoto?
Sure.
Yes, go ahead, Commissioner Miyasato.
Good morning. You had addressed in your development's concern, one of the concerns that you brought up was housing. I believe in the original plan, there was some housing that was proposed in the original plan prior to this.
So in the Kōʻele Project District, there were proposed homes to be built, but they were all proposed as resort home, second home developments. And in the time that we have gone through this process, we've already added 150 new homes for workforce specifically. So in terms of like the thought that the testifier raised about 500 additional jobs or homes being required, the expansion that we're requesting is actually very small. The number of positions that are filled today at the existing hotel doesn't even come close to the number that she brought up. It's only like 130 people that have are employed there. And so the expansion is going to be even a fraction of that, a small fraction. So we anticipate there will be some housing needs, but it's not going to be this significant expansion of homes required.
Okay, and would you be able to comment on the original development that they have satisfied all of their affordable housing obligations?
Yes. So from the original development, the prior developer had added, but well, I can't say specifically for that property, but for the two resorts, they added well over 400 additional housing units. We've added in the 150 homes that we provided, it wasn't driven by any particular entitlement conditions. It was just something that we decided to add. And of the 150 homes, 51% of those homes are designated as affordable housing, and they'll remain that way in perpetuity. In addition to that, we have other housing spread out throughout Lanai City that we have committed to affordable housing and maintaining it that way, even though the condition for that has already expired.
Okay, thank you.
Chair, I got another question.
Please proceed.
With all these additional homes and people moving in or hopefully moving in, what's going to happen with the wastewater treatment plant? Is that going to be sufficient to provide whatever services that needs to be provided? Is it big enough?
So for the expansion of the hotel and any additional homes that are actually being planned, the wastewater treatment facility is adequate. And I believe the county also has plans to make some improvements that will help the capacity of that existing wastewater treatment plant.
All right, thank you, boss. Thank you.
Commissioners, any further questions for Mr. Matsumoto? Okay, seeing none, Mr. Chip Chase, your next witness.
Thank you, Chair. I'm going to call Dr. Keiki Dancel as my next witness. And before I ask her to introduce herself and for you to swear her in, I'll just point the commissioners to a couple of things to address some of the questions that we heard of Mr. Matsumoto. As Dr. Dancel will explain, the hotel portion of this proposed project district or this amendment to the district boundary is only up to 9 units. And so it's a very modest expansion of that component, as Kurt mentioned, completely offset by the substantial reduction in second homes or luxury resort home development that had been approved. He mentioned the Hopewell project, the affordable housing project. That was a 201H project, and it did come through this commission. As Kurt mentioned, it was not required as a condition, but was a need that Pūlama Lanai saw for the island, and so voluntarily engaged in that development. And if you haven't had a chance to visit it, I encourage it. It's incredibly done. It's a beautiful project, and the commission was broadly supportive of it, and we certainly appreciated that. With respect to water, Commissioner, the EA, which is part of the record and which was accepted by the Lanai Planning Commission, details the water impact. That's also reflected in written testimony before the commission, and Dr. Dancel will touch on it as well. The short story is that and as the commenting agencies have confirmed, there's not anticipated to be any substantial impact on water resources, and that water resources are adequate to meet the needs of the proposed project district without either reaching the sustainable yield levels set out in the Commission on Water Resource Management or the trigger points that the Commission on Water Resource Management identified for closer looks at aquifer impacts. And so we're well below both of those. And then lastly, with respect to wastewater, that's also addressed in the EA and in written testimony, and Dr. Dancel will touch on it today. And the short story on that is the capacity is more than adequate for the anticipated needs of this limited project district alignment. And so with that additional information, Chair, I call Dr. Dancel.
Thank you, Mr. Chip Chase. Dr. Dancel, please state your name for the record.
Aloha, Commissioners. My name is Keiki Dancel.
Dr. Dancel, do you swear or affirm that the testimony you're about to give is the truth?
I do affirm.
Please proceed.
Thank you, Chair. Dr. Dancel, can you identify for us your position with Pūlama Lanai?
Hello, Commissioners. I serve as the Senior Vice President of Government Affairs and Strategic Planning for Pūlama Lanai.
And within that title, can you identify for us or describe your responsibilities?
Yes, I oversee strategic planning, project management, permitting and entitlements, and regulatory policy matters for Pūlama Lanai. I also have the responsibility for community development and cultural and historic preservation, which means I am involved in both the community engagement and cultural research aspects of the project like this. Much of my role is coordinating across internal teams, outside consultants, so that projects move through the planning, public review, approvals, and implementation in a coordinated way.
And Dr. Dancel, help us understand just a little bit about your educational and professional background that you brought to those roles at Pūlama Lanai.
My educational background includes a PhD in chemistry from the University of California, San Diego, and an MBA from Harvard Business School. That background has provided me a strong analytical and strategic planning foundation. Professionally, I have business development and strategy for nearly decades, served in current Pūlama Lanai for nearly 7 years. I have also previously testified before the Land Use Commission in connection with the environmental assessment for the 201H project that Mr. Chipche said, as well as the environmental assessments for other projects on Lanai, most recently the Mickey Industrial Park.
And what has been your role in this particular petition, this petition for district boundary amendment for the Kōʻele project district?
So I've been involved since the early stages of this process, which includes environmental assessment, community, as well as the Lanai Planning Commission presentations and community plan amendment, change in zoning, project district amendment, and related county council processes. I've also reviewed the technical studies prepared for the petition and helped coordinate responses to comments from agencies, departments, and community members.
We're going to start taking a closer look at the petition area. And so we've put a slide up on the screen. Dr. Dancel or Keiki Pua, can you help orient us to this area of Lanai?
Sure. So here's the island of Lanai, and in red circled is the project area. And then the larger image here is a zoomed in area, and it's comprised of 3 separate TMKs. It's located adjacent to Sensei Lanai, a Four Seasons resort, and north of Lanai City.
Kurt, during his testimony, referred to this area, and other speakers have done the same thing, as being within a project district. What is a project district?
Yes, a project district is a county planning tool and zoning designation that's used usually for larger and unique master plans areas. It's more flexible approach that makes sense for larger developments, instead of relying on specific standard zoning categories that the county has. It also creates a project-specific framework for the area, which allows for a multitude of uses. So as you can see in the colors, those are different uses, but the entire area is called a project district. For Kōʻele, the project district designation is the community plan. So the community plan has different designations, and this area here is all zoned project district, and that's why there's sub-district, which are the individual uses. But for the community plan, it is zoned it is zoned project district.
And so you reference the map up on the screen. We've put another couple of figures on it. On our left-hand side is the existing, and on the right-hand side are the proposed. I'd like you to walk us through the changes that are proposed for the project district, and for which this district boundary amendment would be one step of the process.
Sure. So right now, this is the project district on the left. And as you can see, purple is zone golf course. And what our plan is to do is to change a majority of that purple area to pink, which is zone park sub-district. And Mr. Matsumoto spoke of the large amount of resort residential or second homes that was originally part of this master plan development, Kōʻele. And the plan is to take out a majority of that and turn it in, a lot of it gets turned into park and open space. And some of it actually gets removed. A lot of this area here was already built before Kōʻele became Kōʻele. So there's a large number of homes that are in that area that were built pre the project district being established. And so we're just taking those areas out.
And I don't think you focused on this, so I'll just ask the question. Right adjacent to Kōʻele, we see 2 areas outlined in red. What's the proposal for that area?
So this is part of the petition area here, one of those TMKs, and that's already being used as it's in use today for part of the resort. It's Lanai Ranch, and Lanai Ranch is here, and the stables are here, and those are amenities to the resorts. And then this area here is used for Pūlama Lanai operations. So those are the 2 areas in the petition today that are not part of project district. The other part of the petition is up in here, but that's already part of the project district.
Okay, and so to summarize then, the areas that we've outlined in red are the additions to the project district area. The rest of it is either existing in part of the project district and will remain so, or is actually being removed. Is that all fair?
Yes. So for the petition today,
Yes.
yes, for the petition today, these areas are being added to the project district.
I want to talk a little bit about the community engagement. And so we put up another slide on the screen sort of highlighting major points in that engagement. Is it accurate to say, Keiki, that before Pūlama Lanai filed any of the applications for entitlements or approvals, that it had already begun engaging with the community on these changes?
Yes. So down here are just some flyers in 2017. So 27, and again, this was when we first raised the idea, and it was closing the golf course and repositioning the hotel to a wellness retreat, and also the discussion about turning the golf course into a sculpture garden. And Lanai Adventure Park was going to also be proposed, and it continued through, and we did another community meeting talking about the adventure park coming online in the golf course area. We received a special use permit from planning. We had to do that because it's not a permitted use in golf course. And so over time, we've had multiple community meetings, as well as small group meetings all along the way.
And did that opportunity for engagement with the community continue after the applications were filed?
Yes. So we filed in 2021 to the planning department. And at each step of the way, we continued to engage the community throughout these different processes, whether it was with the Lanai Planning Commission or at the Housing and Land Use Committee or at the Maui County Council.
And so you mentioned that the formal entitlement process began in 2021, so roughly 5 years ago. Was that first step the environmental review?
Correct. The first step was environmental review.
Who is the accepting authority for that environmental review?
The accepting authority was the Lanai Planning Commission.
And did the commission accept the environmental assessment?
They did. Unanimously.
Did that include a public hearing on even just that first part, the environmental review?
It did.
And did the environmental review detail the changes to the project district that were proposed and that we're now seeing move through the rest of the regulatory process?
Yes, it included everything.
After the environmental assessment was accepted by the Lanai Planning Commission, what did Pūlama Lanai take as its next step to approve the changes to the district?
So the next step was to present to the Lanai Planning Commission, and there were 3 public meetings in which we presented to the Lanai Planning Commission.
Following the Lanai Planning Commission was the next step to go to the County Council.
It was. So after we finished, we moved on to the County Council, specifically the Housing and Land Use Committee.
And I understand the committee approved and then the full council approved after 2 readings. Is that right?
That is correct. Maui County Council approved it first and second reading, and the mayor signed it.
And so where in this process that we've set up on the screen are we now?
We are right here at the state land use. I also wanted to say that we actually went back to Lanai. It was an in-person public meeting to ratify. So it was another additional step back to the community in person.
And so you've identified where we are now. What's left to do after the Land Use Commission review?
Should we be able to move successfully through this step, we will have to go back to the Housing and Land Use Committee, and they will hear the same presentation in which they heard back in 2024. The only change will be your decision here today.
I mentioned earlier, Kikipua, the ping-ponging, and so we've set up the pings and the pongs on the screen now. Can you walk us through how those alignments between community plan to district boundary to zoning work?
Yes. So community plan, before we could come before you, the community plan had to have all of the petition areas zoned project district. We were successful at that. And so now we're here before you today because some of those areas are zoned rural and agricultural, and we need those changed to urban because they all have urban uses within them today as existing uses. And then we will go back to the county once it is all zone urban and ask for the change in zoning and project district phase 1 amendment.
So Kikipua, the project district that you've mentioned, this unique Maui County planning tool, has an additional element to it, which is that any use within the project district must go through a further approval by the Lanai Planning Commission. Is that accurate?
That is accurate. After we are granted the change in zoning and project district phase 1 amendment, any project that comes forward within the project district has to go to the Lanai Planning Commission as the decision-making authority, and they will review the project details. They will review, for example, the number of additional spa halls, the amount of water that's being used, the amount of wastewater, any impacts on traffic. So we go through like a mini EA all over again, just for that specific project within the project district.
And so even after the EA and the community plan amendment and the DBA and the zoning, there's still further approvals, including public hearings, that will be required. Is that right?
That is correct.
I want to dive in a little bit deeper now into the particular areas that are part of the petition. We put up another slide on the screen. This is from our Exhibit 7 to the petition. Can you describe the areas for us?
Yes. So what you see before you is the state land use district map. And here are the different districts. Here in pink is one area, and that is agricultural, and we're going to change that to rural, or that's what we're here today. Here in green, it's rural, and we're going to request to change that to urban. Here outlined in blue is rural. We're requesting to change that to urban. And then there's a small itty bitty little sliver here. It's about 2 point some acres, and that's rural. And we're changing that to urban. And then this area outlined in aqua is green, and we're requesting, and that's agricultural, and we're requesting to change that to urban.
So Kikipua, for our next slide, we've taken that same outline of the different areas and we've put it on an aerial image so that we can see what's on the ground today. Can you walk us through this?
Sure. So the pink area outlined here is part of what we call Lanai Ranch, which is an amenity to Sensei Lanai Four Seasons Resort. And then outlined in green here is the continuation of Lanai Ranch, and then we have some tennis courts as well. So this is majority pasture land, and it will remain in pasture land. Though, and I'll walk through each of the different details later. There is a riding arena here. This place here outlined in this navy blue is where the hotel expansion is contemplated. It's adjacent to the existing and already permitted use in the project district of hotel. We have our Pūlama Lanai operations here. We have some office space here. And then up here is the former golf course area. And this is what we're here today to change this from rural and agricultural to urban. It's adjacent to the adventure park down here.
And focusing on that area, because I think you've covered some of the others, what's the intended use of that former golf course area?
Sure. So let's start up here. So right now, so it's the golf course, as I mentioned, we closed it, but right now we manage that area, our landscape operations, and some of the things contemplated in the park area is a sculpture garden.
If we can bounce to the next area.
Yes. And so this area here, this is just to clean up the maps to make everything align. It's zone rural, and it's just adjacent and part of the operations that will be turned into park. The next area here, this is in pink. and its current designation is agricultural. And like I said, it is used for Lanai Ranch as an amenity for guests and the community. It's primarily pasture lands, where we have some of the animals roaming, and we are turning this into urban because it is an accessory use to the resort, and we could potentially do some special events. And when we talk special events on Lanai, it's not like a major rager concert. It's, you know, appropriately sized for the hotel there today to have, say, a special dinner for some of the guests that want to, say, have a wedding or something like that. The next here in green, like I said, it's tennis courts and Lanai Ranch, some riding arena. Some of the existing is rural. We're changing it to urban. Again, some of the existing, it's going to continue being existing uses as the stables for the ranch animals, as well as some upgrades to the ranch itself. Potential changing this to maybe pickleball courts, but we're not sure. Maybe a tennis pro shop and some restrooms or changing rooms. So they're already existing uses with just some upgrades for some ancillary uses. And last one here, as I mentioned, this is currently rural. It's being used for Pūlama Lanai operations. Our team has offices there, and just for context, this is where structures C and D, we use them for office space at this time. And then we are planning to expand the hotel area, which again, as I said, is right adjacent to the existing hotel. And we're contemplating up to 9 villas and spa halls and some support structures. So the reason why we're contemplating villas, it was a different type of room type. Right now, there's no other room type at the hotel that has a standalone area for guests to stay in. Right now, there's just a few suites, and that's some of the requests so that we can remain competitive on island for choices of where people want to go and choose their next vacation.
And so looking broadly at these areas, does an urban district designation align them with those proposed uses that you've outlined and with the community plan for the Kōʻele project district?
Yes, an urban reclassification is appropriate because this area is immediately adjacent to the existing Sensei Lanai Four Seasons Resort area, and the Lanai Community Plan and Kōʻele Project District framework already recognize and contemplate hotel-related uses in this location. The anticipated expansion is limited, like I said, to 9 villas, some spa halls, and resort support structures. So it is an appropriate reclassification.
And Kikipua, what's the timetable anticipated for implementing the proposed uses?
So the projected timetable is within the statutory 10-year period. As I mentioned, most of the petition area will continue in its existing uses with potential upgrades or some ancillary improvements to support these uses. The smaller area, the 11.54 hotel subdistrict, will require, as I mentioned before, additional county review and approvals, as well as construction. And this will take a long time. There's no statutory deadline for that. And we have to go through that process. So the entitlement process is unknown, but we are aiming to get it done in the 10-year statutory period.
I'd like to just highlight some of the assessments and reviews that were done for these requested changes. We've put up a table on the screen that captures, I think, most of them. Does this table summarize for the commission the reviews that have been conducted?
Yes, apart from the archaeological and cultural assessments, which will be covered by Dr. Kehal Watson later.
Water's come up a couple of times, and importantly so. Is it correct that the projected water demand for the entire petition area is 59,000 gallons a day?
That is correct.
Is it also accurate that this added demand will not exceed the sustainable yield that the Commission on Water Resource Management has determined, or the trigger points that the Commission has set out?
That is correct. The sustainable yield for Lanai is 6. The current pumping level is about 1.7 million gallons per day, and we are well below the trigger of 4.3 million gallons per day.
And with respect to wastewater, how will wastewater flows be managed to ensure that the project or the proposed uses don't cause an excess or cause us to exceed capacity.
Yes, as Mr. Matsumoto mentioned, the final environmental assessment did state that there is enough capacity. However, when you pull building permits, you have to go through subsequent reviews at the county. And at that time, they can make a recommendation. And if there's any upgrades are necessary, they will make them at that time. But the initial final environmental assessment did state that the Lanai City wastewater treatment plant can accommodate the expansion.
Housing is always an important issue, and it's been discussed some today. Mr. Matsumoto mentioned the anticipated housing impacts being negligible given the intended uses or the expansion of the hotel. What has been the assessment through the reviews and our assessment today of the potential need for housing?
So as I mentioned, most of the petition area will continue as existing in similar uses. And as Mr. Matsumoto said, the workforce that is contemplated in any of the expansion or upgrades to the existing uses are already employed on island today. So we do not see an impact for additional housing.
Keiki-Pū, we're going to put up on the screen just the last slide I believe we have, and that's to discuss the recommended conditions. OPSD has supported the petition with 7 original recommended conditions, 4 additional conditions. Mr. Matsumoto confirmed that Pūlama Lanai agrees to them. I'd like you to do so as well.
Yes, we agree to those conditions.
And in addition to those conditions, LUC staff recommended implementing the seabird lighting mitigation and bat season vegetation management restrictions that were identified in our final environmental assessment. Does Pūlama Lanai agree to implement those conditions as well?
Yes, we are committed to implementing the seabird lighting mitigation and bat season vegetation management restrictions identified in the final environmental assessment as applicable to future activities in the petition area.
And OPSD and then OHA today, we heard recommended continued consultation with the State Historic Preservation Division, in particular for parcels 61 and 01, when any future project is proposed within those areas. Does Pūlama Lanai agree to that condition as well?
Yes, Pūlama Lanai agrees to that condition.
And would that include consultation prior to any ground disturbing activities?
Yes, that is actually a requirement.
Thank you. No further questions, Chair.
Thank you, Council. We're going to take a 5-minute break, and we'll be back at 11:37. Thank you. We're back in action. All right. County of Maui, is there any question for this witness?
No, Chair. Thank you.
OPSD, any questions for Dr. Dancel?
No questions. Thank you.
Commissioners, any questions for Dr. Dancel? Oh, go ahead, Commissioner Miyasato.
Could you go to Exhibit 3, please? Dr. Dancel, while he's pulling that up, what is the elevation on this particular petition area?
Subject to check, but around 1,700, I think.
Okay, so it's from Exhibit 2 is pretty much centralized on the island.
Yes.
And so if I kind of picture the nights, almost like I'm on that peak, right?
There's no peak. We have a mountain range.
Well,
yeah. And it's Makaya, the mountain range.
Okay. How accessible is that property to the general public?
It's very accessible.
Okay. And you're on property that's in those buildings C and D.
Yes. So our Culture and Historic Preservation has their offices there.
Okay, and I believe there was another slide that had shown all your public engagements throughout the process.
Yes.
During those engagements, were there, I guess, concerns brought up about cultural practices?
There were no concerns brought up about cultural practices during the environmental assessment, during the Lanai Planning Commission hearings, the 3 meetings on Maui, at the Housing and Land Use Committee. There were some people that talked about their connection, remembering their families that lived there and the experiences they had with childhood there.
Okay. Are you familiar with the Monroe Trail?
I am.
And that is accessible through that property?
It's accessible through the property and around the property.
Okay, will the public continue to have access? I believe it's closed now, but there's a Jeep trail, right?
There is a Jeep trail that you can get to from the back side. You go by the cemetery and back up that way. You can get through the Monroe that way, or you can come up through the Poloi and come up on the other side. So the Monroe Trail goes across and you can access it both ways.
Okay, so none of this would, I guess, block access from the residents, or I believe it's part of the lottery draw for hunting, also the access.
This cooperative game management area is outside of the petition area.
Okay, so you won't be this additional developments or rezoning won't block any of the access.
Correct. It will not block any of that access.
Okay, thank you.
You're welcome. Thank you, Commissioner.
Thank you. Commissioners, any further questions for this witness? Okay, seeing none, we're now going to take a half-hour lunch break, and then we'll be back. Mel, you need more time?
Oh, we can get that.
Yes.
I'm Mark.
Okay, let's say 45 minutes, so we will be back at 12:30. At least that's our goal. Okay, thank you very much. Okay, everybody, thank you. We're back. Okay, I can't remember. Did we ask the county any questions? I think you guys said no. State had no questions. Commissioners had no questions, and we're in the new witness. Okay, please proceed, Mr. Chip Chase.
Thank you, Chair. I call my third and final witness, Dr. K. Watson.
Okay, thank you, Dr. Watson. Please state your name for the record.
My name is Tricia Kehaulani Watson Sprout.
Dr. Watson, do you swear or affirm that the testimony you're about to give is the truth?
Yes, I do.
Please proceed.
Thank you, Chair. Dr. Watson, would you identify for us your current employment?
I am the president and founder of Honua Consulting. We're a cultural resource management firm.
And Dr. Watson, so that we have some context for your testimony, can you summarize for us your educational and professional background?
Yes, I have a law degree and an environmental law certificate from the William S. Richardson School of Law, and then I have a PhD in American Studies from the University of Hawaii. And then I have 20 years of experience working on cultural resource management reports. I also sit on the State Historic Review Board.
And importantly, Dr. Watson, is it accurate to say that you are my law school classmate?
I am. Yes, I am. So I've known you for quite a few years.
Well, in that long period of time, and it is long now, what are the estimated number of cultural resource projects that you've overseen or participated in?
At least 100, which perhaps dates us. So it's been a few years.
And for Pūlama Lanai, can you describe your involvement with that company?
We oversee all the archaeology work for Pūlama Lanai. We took that on when Tom Dine retired and closed his firm. And then we took his employee that oversees all the Lanai projects. So we've actually worked on Lanai for a number of years, as has my staff.
And both for Pūlama Lanai and for other consulting projects, have you had an opportunity to testify before boards and commissions, including the LUC?
Yes, and the LUC is always my favorite.
And in these opportunities to testify, including before the LUC, were you qualified as an expert witness?
Yes, I was.
And what are you typically qualified as an expert in?
So cultural resource management and historic preservation, and then also the preparing of CIAs, kapa'akai, and that any work that sort of includes traditional and customary practices.
And what was your work for this district boundary petition?
So we did a number of reports for this. So first we did an LRFI, which is a literature review and field investigation. So we completed that a number of years ago. Then we did a kapa'akai, which I think we'll discuss a little bit more. And then also our LRFI recommended an archaeological assessment of the two structures, which was completed by Mason Architects, but they do not do a criterion E assessment, which looks at it for importance for Native Hawaiian or other ethnic groups. So we also completed that component of that project.
And I want to start with the LRFI. We'll put up on the screen one of our figures summarizing some of the review and the project area. And can you summarize for us what is an LRFI?
So a literature review and field inspection, LRFI, is a document that basically is, for lack of a better way to put it, a due diligence report. It's something that CRM firms have used for a number of years. And probably most importantly, recently the law has changed such that now when you submit something to SHPE, you have to include an LRFI as a first step. So it's been in the profession for a while, but it now has specific use.
And did the LRFI for this project identify any historic sites or features?
Yes, there were a number of features that we identified. And then additionally, we also identified the structures C and D. And then something I perhaps just want to clarify because it came up in testimony, the literature review and field investigation included the entire petition area. Our field investigation looked at the two parcels that had not been previously looked at, but that parcel to the right is part of the LRFI, and there have been numerous studies previously completed as to that portion of the petition area.
And was this LRFI of the entire petition area submitted to SHPE?
Yes, it was.
For the Commission's reference, the SHPE response letter is our Exhibit 9. And Dr. Watson, what did SHPE conclude?
SHPE concluded that at this point in the process, the entitlement process, it had, quote, no objections to the proposed Kōʻele project district amendment applications, and that, quote, the permit issuance process for the current permits may proceed. So again, just this district boundary amendment that's before the LUC right now.
And so in practical terms, what does that mean for the permitting process?
So again, for this step, SHPE has approved it proceeding with this step. And then, as we'll discuss, there are future steps that will absolutely include consultation with SHPE.
So then is it fair to say that SHPE's acceptance of the LRFI and authorization to proceed doesn't end the historic review process?
No, not at all. So just going back a step to when I talked about the new law requires, and this is for SHPE and everybody's benefit, to make sure that SHPE has what they now call a complete submittal. So that's now in statute that started July 1st of this year. You now need to have a full description of your ground disturbance. We don't have that yet because the project's not been designed. So we are in full compliance for where we are at this step. And then should we proceed, when we have that additional information, we will again go back to SHPE with the complete submittal, quote unquote, and then SHPE will again review and we will consult with them again.
So what kinds of activities, permitting activities will trigger that future SHPE review?
So again, once there's actual design and the grading and the building permits and those construction permits that will actually include ground disturbance, SHPE will have another opportunity to review all of that when that information is complete and available to SHPE, which it's not at this point.
So then that additional SHPE review will be completed before any ground disturbance?
Absolutely. It's required by law to be.
I'd like to talk a little bit about the kapa'akai analysis. Commissioners, for reference, the analysis is Exhibit 16 to the petition, which the Commission has accepted into the evidence in this proceeding. Dr. Watson, why was a kapa'akai analysis prepared as part of the district boundary amendment petition?
So the kapa'akai analysis is just to aggregate information and make that available to the LUC for their consideration. So in this case, the kapa'akai was a direct response to public input we were getting through. And as Dr. Dancel and Mr. Matsumoto said, this has been a 9-year process. So as conversations with the community occurred and input was provided, we looked very carefully at what the community was most concerned about. So, for example, the 2 structures, C and D, and during earlier proceedings, they brought to our attention that there were oral histories that were previously completed. So one was through the Center of Oral History at the University of Hawaii, which was completed by Mina Morita, who is a native of Lanai. Those were 16 interviews. And then as you have before you, I might get this wrong, Exhibit 6, Part 2, in the EA exhibit, Appendix F to the EA, Kepa Mali prepared a 350-page ethnographic study that included 8 interviews. So the Kapa'akai memo that you see before you took into account the 350-page ethnographic study, plus the 16 interviews that were completed by the Center for Oral History, aggregated all of that with the contemporaneous LRFI. And that's how we identified the practices and the assessment that we conducted. So it's a lot, but all of that is also before the commission for their consideration.
And fair to say then, in evaluating the potential to impact cultural practices, you considered the historical record, the contemporaneous information, and the ongoing community engagement.
Absolutely.
And based on that totality of information, what is your assessment with respect to the potential to impact historic properties through this proposed project?
So for this proposed project and within the petition area, there was not a potential in this case. But I do want to emphasize, we look at the entire region. That's not necessarily in the memo. So I believe, as Commissioner Miyasato mentioned, there is the trail that goes behind this property. There's, of course, hunting. It's Lanai. But also, and this is in the ethnographic study, the Kalokahi Church is nearby, and that is something that Native Hawaiian families have participated in and engaged in for generations. So we're not saying that there aren't practices in the region. There aren't any in this specific petition area, therefore the action won't have an effect. But there are things, particularly the church, which is very strongly supported by the petitioner as to its maintenance and ongoing work.
Let's talk a little bit about the structures that you mentioned, and I think Kurt and Kekipua mentioned as well. They have been identified as in structure C and D. Give us just a little more information about those structures and the assessment of them.
So the structures, as you can see in Mason's report, which is, remind me, exhibit number 14. Thank you very much. They are historic ranch associated. So 2 components. So one, they've been moved multiple times. This is why, and just strictly under the regulations, Mason found that they no longer have integrity, right? So I'm not going to get into all the 7 aspects of integrity because everyone will glance over and it takes a lot of, but because of how they've been moved and modified over the years, they were found to not have historical integrity anymore. This doesn't mean that they're not important to the community. It just means that under the strict guidelines of the law, they didn't meet that criteria. They are currently used for ranch Pūlama Lanai operations, and we do absolutely from day one recognize that they are important to the community, which is why they will be again relocated and then preserved in their current condition and then used for a community museum, which I actually think is a wonderful use for them.
In evaluating those structures, you mentioned that Mason looked at them for criteria A through D.
Yes.
And that in addition, you looked at them under criterion E. Can you help explain both the difference in those reviews and your conclusion?
Okay, so the difference in those reviews, so criterion A through D basically looks at it in overall history, or was there an architect of note that constructed these? So think of the Ossipoff houses, right? Is there someone of noted fame that was involved in the development of it? And Mason found that it didn't meet those criteria. E looks very specifically at Native Hawaiian importance or other ethnic groups. So we looked very carefully at that. And I will, if everybody will humor me 1 second, I'll give an example of a building that can be a modern building like these. They're historic, but they're not pre-contact traditional, but still have importance to Native Hawaiian groups. So the ORNL depot offices across Ala Park. Depot, they're historic in that regard, but because they are used, for example, for the King Kamehameha Celebration Commission and have been used as part of the parades for over 50 years, that's a really good example of a building that is historic, not traditional Hawaiian, but can then have importance to a Native Hawaiian group because of its recent use. So we looked very carefully at, did these two buildings potentially have something like that? Was there a hula halal that had been using it for decades or something of that sort? And we found that it didn't meet that criteria. So again, we recognize it's important to the community, but we didn't find that it met significance under criterion E based on our very careful look at its most recent uses over the last couple of decades.
And did you have an opportunity to read the public testimony that was submitted in particular from OHA and Kōʻele Maui with respect to those structures?
Yes, I did.
And did that change your conclusion in any way?
It did not. And of course, Kepa's the best at everything in the world as far as I'm concerned. So I absolutely did have a conversation with him, and then Kamakana Ferreira of the Office of Hawaiian Affairs, and reiterated Pūlama Lanai's commitment to relocate and preserve those structures and to ensure that the intended museum use, which Mr. Malley has been a part of planning for a number of years, is absolutely going to occur.
And my last question, Dr. Watson, is it fair to say that in addition to the SHPD consultation with respect to any ground disturbing activity, SHPD will be involved in the consultation for any final determination with respect to the location and use of those historic structures?
Yes, absolutely. And as I noted, one, it's required by law. And then two, we just need to emphasize that now under the law, there's a very clear definition of what a complete submittal is. So until that information is available that we can provide to SHPD, SHPD will not even review the project again.
Understood. Thank you. Chair, I have no further questions.
Thank you, Mr. Chip Chase. County Maui, do you have any questions for Dr. Watson?
No, Chair. Thank you.
Thank you. OPSD, any questions for Dr. Watson?
No questions, thank you.
Thank you. Commissioners, any questions for Dr. Watson?
I got one question, Chair. So you're a professional at this, right?
Yeah.
Okay. So all recommending that the commissioners require a supplemental cultural consultation and an updated Kapaka analysis, because I believe Lāna from OHA is claiming that it's outdated. So your professional opinion on the record is not outdated?
No, it's not outdated. My professional opinion.
Thank you.
Any further questions from commissioners for Dr. Watson? Okay, I have a question. It may not be your area, but there was also testimony about the discrepancy in the petition area. Would you want to address that, or should someone else?
I think,
Do you mean the discrepancy with respect to what was covered under the review, which Dr. Watson has covered, or some other issue?
It was in OHA's testimony that the area you guys looked at was different from the her understanding of the area.
I think that's to your
okay. So no, we looked at, as I think I mentioned earlier, the two parcels that included the field investigation are in the petition area, and the overall LRFI looked at the entire petition area, and specifically the area that they mentioned. That is, there have been a number of studies that are, I wrote it down, I'll give it to you. So figures 23 and 24 of the LRFI, and then table 9 and section 3.2 of the LRFI provide substantial detail as to all of the previous studies that have been covered, which extensively cover the entirety of the petition area.
Okay, thank you. Commissioners, any final questions for Dr. Watson? Okay, hearing none, thank you very much.
Thank you.
All right, County of Maui, for planning purposes, could you please provide an estimate of how long you expect your presentation to take? And please include the number of witnesses you plan to call, the approximate time for each witness, and your total estimated presentation time, Mr. Hopper.
Chair, we're only going to call Planning Director Jackie Takakura. I think her testimony will be under 5 minutes, obviously depending on questions.
Okay, please proceed.
Thank you. As stated in its written position statement, as it was filed already in the docket, the County of Maui supports the proposed district boundary amendment for the reasons stated in the petition. I'm going to call Planning Director Jackie Takakura to briefly restate the county's position, but again, we would stand by our written position statement and would be available for any questions of the from the commission. So I would like to call Planning Director Jackie Takakura as the county's witness.
Thank you. Director Takakura, please state your name for the record, and I will swear you in afterwards.
Thank you, Chair. My name is Jackie Takakura, and I'm the Director of Planning for the County of Maui.
Thank you. Director Takakura, do you swear or affirm that the testimony you're about to give is the truth?
Yes.
Okay, please proceed.
Thank you. And this is my first Land Use Commission meeting, so hi. Okay, so as Corporation Counsel Mike Hopper had stated, the Planning Department supports the proposed district boundary amendment. Some of the comments that I heard, I can mention briefly. One is the Water Use and Development Plan, which was last done for the island of Lanai in 2011. The update is in progress, and it is expected to be completed by the end of March 2028. Regarding wastewater, Department of Environmental Management was consulted on this and they had no concerns, but keep in mind that they will be consulted again when Pūlama Lanai submits for the change of zoning. And then every time a building permit comes through, those are routed to the different departments, including Department of Environmental Management. And then also, as I mentioned, there will be a change of zoning. And at that point, the project will be closely reviewed again, and the Lanai Planning Commission may be adding conditions. So this isn't the last, chance to really get a good project going. Generally speaking, when the Department of Planning considers changes to land use entitlements, some of the points that the department considers are community engagement, general plan consistency, infrastructure, historic and cultural review, and environmental impact. As we stated in our June 1st position statement, this project has checked the boxes for all of these points, and the department supports the proposed designation changes. Thank you.
At this point, I wouldn't have any further questions. I can turn it over to the parties as well as the commission in case you have any questions.
Thank you. Petitioner, do you have any questions for County of Maui?
No questions, Chair.
OPSD, do you have any questions for County of Maui?
No questions, thank you.
Thank you. Commissioners, any questions for Director Takakura? Okay, seeing none, thank you very much. All right, State Office of Planning and Sustainable Development. For planning purposes, could you please provide an estimate of how long you expect your presentation to take, and please include the number of witnesses you plan to call, the approximate time for each witness, and your total estimated presentation time.
Thank you. Very brief. I have a few comments under 5 minutes. We have one witness, the Director of OPSD, Alice Evans, and she has a few brief comments as well under 5 minutes.
Okay. So you're going to give your presentation first, right?
Yeah.
Okay, please proceed.
Thank you. Hato for OPSD. OPSD supports approval of the proposed boundary amendment with appropriate conditions to address the state's concern. OPSD previously submitted 7 proposed conditions in our written testimony, which have been accepted by petitioner. And in addition, after further review and consideration of the submissions of the parties and of the testimony submitted by OHA and others, OPSD proposed 4 more conditions that we feel are appropriate. As stated by petitioner, they are in agreement with those conditions. And I'll read them all to you now. First, a condition that prohibits the use of drinking water for land formerly zoned golf course and rezoned to park and open space within the petition area, requiring the use of alternative sources of water. Second, a condition that for any future projects involving ground disturbing activities within the petition area, petitioner must have an archaeological monitoring program and must notify and give SHPD and the opportunity to review and comment on any future projects involving ground disturbing activities within the petition area. Third, a condition that should any archaeological or cultural resources or burials be discovered during any future ground excavation, all construction work shall be ceased immediately. Subsequent work shall proceed only upon archaeological clearance and written guidance from SHPD. And fourth, a condition to relocate and preserve Kōʻele structures C and D in the petition area in consultation with SHPD and the community, including consideration of the potential to adaptively reuse the homes as a museum or interpretive space. OPSD believes these conditions are sufficient to address the state's concerns and recommends approval of the boundary amendment with those conditions. And I'm going to turn this over to Director Mary Alice Evans to give a few brief comments on behalf of the state.
Thank you. Director Evans, please state your name for the record and I will swear you in.
Mary Alice Evans, Director of the State Office of Planning and Sustainable Development.
Thank you. Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Please proceed.
Thank you, Chair. The Office of Planning and Sustainable Development supports the petitioner's proposed reclassification with appropriate conditions to address the state's concerns. This DBA is one part of a series of adjustments to the land use in the Kōʻele Project District and will align the state land use classification with the underlying Lanai Community Plan designations and proposed county zoning and Kōʻele Project District updates. Reclassification of the petition area to a state urban district is appropriate for the area and the intention for the Kōʻele Project District, which is to provide development flexibility while still maintaining certain limitations on future development. The petition area is not well suited for agricultural use, and the proposed development will support tourism and the economy. The studies prepared for the final environmental assessment indicate minimal impact to resources and the environment in the petition area. However, given the uncertain timeline and details of future projects, future updates and consultation are needed to determine impacts at the time those projects move forward. In particular, the Department of Hawaiian Homelands, the Department of Transportation, and the State Historic Preservation Division have requested future consultation and involvement in future projects. So based on the final environmental assessment recommendations and comments received from various state agencies, OPSD has proposed 7 conditions. Language for those conditions were provided in our written testimony, and also you have just heard for additional conditions that we're proposing, and that we understand that the petitioner is agreeable to those conditions. Thank you.
Thank you, Director Evans. Petitioner, do you have any questions for Director Evans?
No, Chair.
Thank you. County Maui, do you have any questions for Director Evans?
No, Chair.
Thank you. Commissioners, any questions for Director Evans? Okay, seeing none, thank you very much. All right, Petitioner, do you have any closing arguments that you would like to make at this time?
Yes, Chair, I'm prepared to close.
Please proceed.
Thank you, Chair. Members, thank you for your attention to our presentation today. At the end of my closing, I'll note the additional evidence, including these slides, to be admitted for the record so that we ensure a complete record before the Commission. But I'll start with the broadest picture I can, and that is the standard for approval. As Mr. Derrickson explained at the beginning, the standard for this Commission is a clear preponderance of the evidence. That standard has a number of considerations associated with it. They are whether the petition is reasonable, whether it's not violative of Chapter 205 or Section 205-2, and is it consistent with the policies and criteria established pursuant to 3 separate statutes, Section 205-16, Section 205-17, and Section 205A-2. I'll go through each of those requirements. The first being whether the petition is reasonable. As we've shown through the submission of the information and through the testimony today, this district boundary amendment is really to align the uses and land use designations for the petition area with the existing county approval, with the community plan. So it was really a ground up effort from the community on Lanai to the state, rather state to the community on Lanai. This petition area is partially undeveloped, prior golf course land, pasture land, tennis courts, and stables. As the OPSD has explained, not suitable uses for agriculture and not currently used for agriculture. And then lastly, there's no potential for sprawl because it is adjacent to the existing urban areas that are part of the project district. With respect to consistency with county planning, as the director for the County Department of Planning explained, the county is supportive of the petition, and the petition is consistent with the community plan for the area. The last step in the zoning change will be to go through the county process to confirm or reject the adoption of the zoning for the project district. The third requirement has those sub-requirements that I mentioned, and the first is consistency with the Hawaii State Plan. We've detailed conformance with the Hawaii State Plan on pages 37 to 39 of the petition. The second is consistency with the policies and criteria of the CZMA program, the Coastal Zone Management Act. We are substantially outside of any special management area, and are otherwise consistent with the policies adopted under those statutes. That takes us to the third subpart, that's section 205A-17. That in turn has 6 factors. The first factor goes to the state functional plans. We detail those again on page 37 to 39. The second factor goes to the project to district standards. Here we meet those as we discuss on pages 51 through 53 of the petition. The third factor is the impact of the proposed reclassification on various areas of concern. All of those areas of concern have been reviewed through the environmental assessment, through consultation with agencies, and are set out in the petition and the exhibits that we have before you, including any impact on resources and on state housing. And so we come then to the point where we have met all of the standards for approval under a clear preponderance of the evidence, where the consulting agencies have recommended approval, provided that we agree to the conditions as OPSD has explained and I've explained. We do agree to the 7 conditions that OPSD set out in its initial testimony and position statement. I put those up on the screen. And we've agreed to the additional 4 conditions that counsel for OPSD read into the record. We've put those up on the screen, and with the inclusion of these slides as an exhibit or as part of the record, they will be in writing part of the record before the Land Use Commission as well. And so, commissioners, with respect, we believe that we have met the standard for approval, that this is an important step in the process, but not the first or the only step in the process. And that what we're asking the commission to do today is follow the path that has been really laid, as I said, from the ground up, from the community up, through the Lanai Planning Commission, through the Maui County Council, to this commission, and then give us that opportunity to go back to the County Council to approve or at least consider the rezoning applications. And then finally, before any development of this area can proceed, go back to the Lanai Planning Commission for what's called the Phase 2 approval within the project district, and then to the planning director for what's called a Phase 3 approval for the planning or within the project district. As you can see, it has been a multi-year effort already. It will be a multi-year effort going forward, and all the agencies, the communities, the appropriate parties will be consulted as they have been in the past going forward today. And so I appreciate your time again, and we would ask for approval of the petition. My last housekeeping is to say that in addition to the exhibits that Chair asked me to describe at the beginning, I believe the record or full record should include the notice of hearing, our response to OPSD, our witness list, the direct testimony that we submitted to the Land Use Commission, the affidavit of mailing, and then the slide presentation that you were shown today. And so I would ask that those documents be formally admitted to the record so that we have a complete record of decision before this commission. Thank you.
Thank you, Mr. Chip Chase. Do you know what you would like those exhibits to be numbered as?
Yes, Chair. We would take them as the next exhibits or next numbers in order. We, with the petition, had exhibits 1 through 16, as I described. So we would take each as the next exhibits in order.
All right. 17, 18, 19.
I'll do some counting if I can. So exhibit 17 would be the notice of hearing. Exhibit 18 would be the response to OPSD. 19 would be the witness list. 20 collectively would be the direct testimony. We'll compile that. 21 would be the affidavit of mailing, and 22 would be the slides.
Okay, thank you, Mr. Chip Chase.
Thank you, Chair.
County of Maui, do you have any closing arguments that you would like to make? I'm sorry. I see. Before we proceed on that, our legal counsel advises me to ask, does anyone have any objections to those lists of exhibits?
No, Chair.
Okay. OPSD, do you have any objections to those list of exhibits by the petitioner?
I'm sorry. Could you repeat that?
Sure, Ms. Kato. Do you have any objections to the list of exhibits that the petitioner just noted?
Oh, we do not. Thank you.
Okay,
Yep.
thank you. There. Yes.
I believe that we have amended exhibits up to 26 on the record.
So we might have to renumber that then?
I have to do some renumbering here.
Okay. Is that critical that we have that exact at this point? I'm being told. Okay. Please just submit an updated exhibit list for us.
Will do, Chair. Appreciate that.
Thank you. Okay, County of Maui, do you have any closing arguments that you would like to make?
Just briefly, Chair, the county is in agreement that the petition meets the criteria for a district boundary amendment. We would note the community plan has already been amended in order to have this project to be in conformance with the proposed project. And the county council will have another opportunity to review the zoning, and the planning commission will as well in the future. But at this time, we do support the reclassification as is consistent with HRS and other required constitutional standards, and would stand by its position statement in the docket. Thank you.
Thank you, Mr. Hopper. Office of Planning and Sustainable Development, any closing arguments that you would like to make?
I just have a small change that I'd like to make to one of the conditions, just because it was stated, a certain phrase was stated in the petitioner's case a few times. Yeah. So the petitioner's witness did indicate regarding a Kōʻele structure C and D that they would relocate and preserve, and in the original version that we had, it just says to relocate. So I just wanted to add and preserve.
And preserve.
And we agree to that change, Chair.
That's an important distinction. So thank you. Any objections from the petitioner?
No, Chair.
County of Maui, any objections to the clarification?
No, not to the condition change, no.
Thank you. Commissioners, any questions about the clarification? Okay, seeing none, thank you very much. Okay, petitioner, do you now wish to make any rebuttal comments?
No, Chair.
Okay, commissioners, do you have any final questions or comments for any of the parties? Okay, seeing none, we'll now open a second round of public testimony for any new or additional comments only. For anyone participating via Zoom, please notify the Chief Clerk using the question and answer feature. Ms. Kwan, are there any requests now to testify?
Seeing none in the Q&A feature, Chair.
Okay, thank you very much. Okay, given that the parties have finished presenting their cases and final arguments before the State Land Use Commission, I declare that the evidentiary portion of this proceeding has been completed. The Commission will now establish a schedule for the post-hearing filings that will assist the Commission in preparing this matter for decision-making. Pursuant to Section 15-15-82, I direct the parties to draft their individual proposed findings of fact, conclusions of law, and decision in order based upon the record in this docket. I want to note to the parties that the Commission has standard conditions which we would like the parties to include in preparing the proposed orders. A copy of the standard conditions may be obtained from the Commission staff, and I recommend that the parties consult with the Commission staff early in the process to ensure that technical and substantive formatting and non-substantive formatting protocols observed by the Commission are adhered to. A proposed decision and order shall be filed with the Commission consisting of 1 paper copy and 1 electronic copy. The electronic copy is required to be ADA compliant, and additionally, a copy shall be served upon each party to this proceeding. Each party to this proceeding shall be given the opportunity to comment on each proposed decision and order filed with the Commission. If a party would like to enter into a stipulation or partial stipulation as authorized in Section 15-15-82.1, the party shall nevertheless file a proposed decision and order indicating the findings of fact, conclusions of law, and proposed conditions that are stipulated to and also set forth proposed for findings of fact, conclusions of law, and proposed conditions that it proposes that are different than the stipulation. The proposed finding of fact must reference to filings on the record and transcripts citing the witness as well as the date, page, and line numbers to identify your facts. Please note that transcripts take about 2 weeks for processing. However, the petitioner has already requested staff to expedite the transcripts, which should be ready by Monday, August 3rd, 2026, and available to all parties. Based on the discussion today, we propose the following deadlines. The petitioner and other parties can submit their proposed decision and orders, DNOs, to the LUC and all parties within 3 weeks after the transcripts are made available and no later than the close of business on August 25th, 2026. We will allow 3 weeks to submit comments, stipulations, or objections to the parties' respective proposals. These shall be filed with the Commission and served upon the other parties no later than the close of business on September 15th, 2026. The deadline for any rebuttals will be within 3 weeks and no later than the close of business on October 6th, 2026. We will then allow 3 weeks for LUC staff to review and complete their staff report and an LUC proposed DNO no later than October 27, 2026. The next hearing that would fit that time frame would be November 18, 2026. Are there any comments from the parties regarding this proposed schedule?
Yes, Chair, for petitioners, Calchip Chase. I had an opportunity to discuss with OPSD and stipulation, and so the expectation is, given the broad agreement on the evidence, the conditions, and the appropriateness of this petition, that we will enter into a stipulation among the parties to submit a single decision and order to the Commission for consideration. And so I think with that, we can substantially shorten the review time and the number of filings that we need to make in this case. Looking at the Commission's schedule with the executive officer and in consultation with OPSD, I would propose that the petitioner circulate the draft or proposed stipulation to the parties by August 3rd. We can do that based on the recording, even though the transcript won't be available until probably that date or shortly before then. That gives OPSD and the county 2 weeks to review the proposed stipulation, and I would ask that we'll submit it to the LUC, of course, at the same time as well, that we schedule the decision-making in this matter for August 19th, when the Commission is scheduled to be on Maui anyway. Then if the Commission votes to approve the district boundary amendment at that decision or at that meeting, that we schedule the adoption of the order for the following month. I believe the Commission is scheduled to be on island again during its second meeting cycle that month. And so that would allow us to complete this process, which has been going on for a while now, by the end of September, which would enable us to go to the next phase to get back to the Maui County Council. And so if that's agreeable to the chair and to the members, I believe that it's acceptable to the parties as well.
Thank you, Mr. Chip Chase. County of Maui, do you have any objections to that schedule?
Yeah, I think 2 weeks would be okay for our review. Thank you.
Okay, OPSD, just want to confirm, are you okay with that schedule?
Yes, OPSD is okay with that schedule. Thank you.
Okay. Okay, that schedule is fine with me.
Thank you, Chair.
Thank you.
Yeah, I believe we're done.
Fair. Based on the venue we're using on August 19th, I don't know if we'll be able to do 2 dockets in one day. The venue is going to kick us out at a 4 p.m. hard stop for 2 dockets.
Okay, that's when we have Kōʻele, Lāna.
Yeah, we have an SP that is taking priority because that is a 45-day turnaround. And then we have this DBA that has a 365-day deadline.
Okay, so we might have to do it. Would the 20th be available, you think?
I will have to confirm a venue because I don't have a venue for the 20th right now.
So the solar project is also mine. So that's a nice synergy also. I'll be here anyway. It was unanimously recommended for approval by the Maui Island Planning Commission. And I don't expect that matter to consume a substantial amount of time. I've been wrong before, and I may be wrong then, but
even monkeys can fall off trees.
Yeah, exactly. It's an interesting comment. I think it meant for you, Chris. You must be my monkey. No, I'm kidding. But I do think we can get through that day.
Okay, thank you. Mr. Ordinker.
Yeah, I believe so as well. And I will discuss with Lāna how we can handle the situation.
Okay, well, that's our goal then. Okay, August 19th.
Sounds good, Chair.
Thank you. All right, I believe we're done here for this portion of the agenda. Thank you, all parties. Thank you, County of Maui, OPSD, Mr. Chip Chase, and Petitioner. Thank you so much for your time here today.
And thank you, members. I appreciate it.
Thank you. Okay, we're going to blast right through, or do we need a break? Blast through it. Okay. All right. Because we were here at 12:30, right? So
we don't have to rush. We have a later flight, so.
Oh, some folks want to rush. Okay, you know what? Let's take a 3 to 5 minute break then. Okay, thank you. On agenda item number 3, the adoption of minutes. This next order of business is the approval of the June 24th, 2026 meeting minutes. Ms. Kwan, yes? Oh, well, hold on. Ms. Kwan, has there been any written testimony received on the minutes?
Yes, Mr. Chair, we received 1 written testimony in opposition from the petitioner.
Okay, Val? This is like a job security for you here.
Good afternoon, petitioners. Count Chip Chase. We did submit written testimony in opposition to the minutes. We believe that the minutes did not accurately capture portions of the discussion, and so we submitted the opposition, really, or the objection, simply to conform the minutes to what we understood the discussion and the decision to be, and to be based on. I have nothing further to add to the comments we submitted.
Okay, commissioners, any questions for Mr. Chip Chase? Okay, I'm going to ask our legal counsel, what is her opinion on this situation?
It's up to the commission whether or not the proposed minutes accurately reflect what happened at the June 24th meeting. The commission can either accept the minutes or it can propose amendments to the minutes if it thinks that the current minutes that are proposed are not accurate.
Okay, thank you. All right, any questions for our Madam Deputy and commissioners on that? Go ahead, Commissioner Curtis.
What areas of the minutes is inaccurate?
Go ahead, Mr. Chip Chase.
As we set out in the written comments, and I don't mean to expand beyond that. I wasn't even going to be called up, or I wasn't even going to say anything, but Ariana made me. We believe that the basis for decision was different than was expressed in the minutes, that included observations or evidence that was not reflected in the record before the commission. And so we put in the objections. I understand it's entirely up to the commission whether to agree with the objections and make modifications or to adopt the minutes as presented.
Okay, thank you. Noted for the record. Any other questions for Mr. Chipchase? Go ahead. I will say Commissioner Miyasato and then Commissioner Wu.
My question is more, I guess, to staff that is the minutes more of a accurate outline and the official meeting is within the transcripts?
You know, you want to answer that? I think, yeah, I think legal counsel should answer that. Oh, okay. So Mr. Ordenker.
We assemble the minutes based on as a summary, a general summary of what occurred during the hearing. I think that the transcripts are more important than the minutes. But I don't know. I'm actually not sure how the courts would view that. If they're inconsistent, my suspicion is that the transcripts would probably override any inconsistency in the minutes.
I got a question. Go ahead. I got a question. So, what minutes are we going to approve? If there's what attorneys claiming there's an inaccuracy in the minutes that we are currently looking at approving, what do we approve?
You can make a revision to the minutes that we can change.
Yeah, so I'm not sure what changes are being recommended that we make.
Do
you have it in our packet?
It's in his testimony, I think.
Yeah,
It was emailed to all the commissioners.
Yeah.
I didn't look at it. And keep.
Okay, so we have a couple options here. It's up to the commission to vote on those minutes. And if you don't feel secure or you feel comfortable doing that, we can go into executive session and ask for more detail from our legal counsel, but that's going to take a little bit more time, but it's up to you guys. What's your pleasure? Anyone? Go ahead, Commissioner Wu.
I think maybe we should give a second look at the minutes and maybe defer it. Okay. Maybe take it up at the next hearing, if that's okay. People.
I'll make a motion that we do that we table it.
Okay. Okay. Mr. Chipchase, do you have some suggested language for correction of those minutes?
If I wasn't prepared to make those suggestions today, but if we do, or if the commission does defer it, then I will submit my suggestions to the commission prior to the next hearing.
Okay. Are we fine with deferring this portion?
Motion.
Okay. All right. Okay. We don't need a vote, right? Okay. Let's do that then. Thank you. Thank you, Mr. Chipchase. We're going to defer this agenda item.
Defer. We don't need to.
Right. We're going to let Mr. Chipchase go have his freedom now.
I am going to run off if that's all right.
Yes. Thank you. Thank you. Safe travels. Okay.
What please?
All right. We're going to go to agenda item number 4, evaluation results for the executive officers' performance evals for fiscal year 2026. This next agenda item, the commission will review and discuss the results of the executive officers' annual performance evaluation and may consider any corresponding modifications to the executive officer's employment agreement. We will now recognize any written public testimony submitted on this matter. Ms. Kwan, has there been any written testimony submitted on this matter?
No, Mr. Chair.
Ms. Kwan, are there any members of the public that wish to testify on this matter?
Seeing none in the Q&A feature, Chair.
Okay, thank you very much. Mr. Ordenker, do you want this evaluation to take place in open session?
I am okay with this taking place in open session.
Thank you very much. Now, at our previous meeting on June 24th, the commission decided that the evaluation forms would be distributed to all commissioners. I requested that the first vice chair, Makia Ohelo, collect and compile the completed evaluation. And thank you very much, Commissioner Kamakeo Hello. You're welcome. Now, Vice Chair Kamakeo Hello, will you please share the results of the evaluation?
Sure. Just for the record, the results is just a summary, total. And I've taken the averages. So the final assessment average is 3.86. And with a few notes there. Is there anything else you need from me at this moment?
No, that's all.
Yeah, I figure we keep this conversation simple.
Thank you very much. Okay, commissioners, are there any proposed suggestions or modifications to the executive officer's contract at this time? And I want to note that you did all receive documents regarding the bargaining unit 13, as well as the budget for the LUC this next fiscal year. And so at this time, are there any proposed suggestions or modifications to the contract?
Chair, if I may, I just want to expand a little bit, if you allow me the opportunity.
Sure.
Just for the record, the grading scale for this evaluation is 1 to 5. 1 meaning that it doesn't meet or that the EO doesn't meet, 3 meaning that it meets, and then 5 meaning that it exceeds. So again, for the record, the collective average was 3.86, which means that he overly meets his kuleana.
Thank you very much for that clarification, Commissioner. All right, you guys have the information before you. I believe that the bargaining unit rate is fair, and I'm open right now to anyone with a proposal for any increase or adjustment for this upcoming year. Anyone wishes to make a motion?
Chair, make a motion that we follow the unit recommended but their percentage of increase.
Okay. Is there a second?
So wait, so I got a couple questions. So the bargaining unit 13, I believe, got 2.95%. Right. There is also one statement in the, well, actually, there's also 1%. What is a 4% step movement?
I'm sorry, what was that?
It's called a step movement percentage.
Yeah, my understanding is since our executive officer is at the top of the scale, there is no step.
Oh,
yeah,
I see.
above that. Yeah, so
on the top.
Well, actually, what that really refers to is that if you're in that bargaining unit, there are various levels, for pay. There is a step increase that you get when you move up in the system, and so the bargaining unit increase is.
So in addition to the bargaining unit increase, there's up to a 4% step up.
Yeah.
If you're eligible for it.
Yeah.
Is that what it is? Oh,
yeah.
Okay.
I am not the reference to bargaining unit 13. I am not a member of bargaining unit 13. It's just that was the reference that the commissioners decided to use in my contract. This commission is free to do whatever they want over that. I don't get the step increases, but it's up to the commission.
There were step increases last year, but you didn't get any. Okay, and then all right.
You're the next, and don't get it every year. Get every 2 years at documents
and
sit out. So basically, you warn it if you're paying for 20 years.
Step. Okay, I just want to summarize that. Mr. Derksen noted that the step increases are based on your years of service, and you don't always guarantee to get it. Is that correct?
Get it every year. You get it every 2 or 3 years, depending on the step.
Okay.
The percentage increase is that's the general negotiated increase of the bargaining unit. You get that as part of the
collective bargaining agreement, but whether or not you get a step increase is based upon years of service.
I got another question.
Yeah, I think though that like last year there was a $2,000 lump sum for those who did not qualify for the step. You know, if they're at the highest step. So,
right, that's something different. That's when you top out. So, like myself, I've been in for so long that I have maxed out my step increases. So I no longer get step increases based on years of service.
But you would have gotten the 2,000 last year,
right? Because that was part of the collective bargaining.
Or last year, yes.
Right.
Okay. Is there any other discussion on this?
Well, I got one question. So you're the only exempt employee at
It's a land use commission.
staff?
No, Arnold Wong is also.
Oh, Arnold Wong. And Scott is bargaining unit?
Yeah.
Oh, so he falls under these guidelines.
Yeah.
And you're exempt. Thank you.
Okay. Commissioner Wu?
Question, yeah. And sorry, I don't know how this work. You know, I was the processes of step raises, but does the raise that he gets or doesn't get, is it reflective on the percentage raise that the staff will get too, or is it totally separate?
It's totally separate.
Okay.
The staff is all civil service except for Arnold, and their raises are completely dependent upon the bargaining agreement.
Got it. So they're not bargaining unit 13 though, right?
It's 13.
Okay, thank you. All right. Once again, are there any other members of the public who wish to provide new or additional testimony on this matter? Ms. Kwan.
Seeing none in the Q&A feature.
Okay, thank you. All right, let me ask it once again for Commissioner Miyasato to restate his motion.
Hey, Chair, this is Kuike.
Yes.
I just have a question for our deputy, or even you as chair. Do we have to vote to accept this evaluation first before we move on any motion or taking any action on it? That way, for the record, it's super clean and clear.
Sure. Good question. Legal counsel?
We asked to my rate vote on that, thanks.
We did?
Yeah, I'm sorry, you did.
Yeah. The question is, do we have to accept the evaluation?
Sure. So I think you can do it in one motion if you want, but if you want to do it in two, that's fine. You can either accept it and then vote on what the raise is, or you can,
right.
I think you can just do it in one though. You can say this, we accept the results and the raise will be.
Let's save time and ask Commissioner Miyasato to state that as described.
Motion to accept our evaluation on the record, and that we approve the percentage raise for step 13.
Based on the bargaining unit 13.
Based on bargaining unit 13.
Thank you very much. Is there a second?
Second.
The motion has been seconded by Commissioner Bradshaw. Is there any discussion? Any discussion? Hearing none?
Hold on, Chair.
Oh, go ahead.
Just a point of clarification on the motion. Are we only addressing the increase, or are we also moving to extend the contract, or is that a separate discussion?
We are not extending the contract in this motion, as I understand it, but someone could make that motion, but that is not the motion that has been made and seconded at this time. If you want to amend it, you can offer an amendment. Okay. All right. Are we good? Okay. Any further discussion? Hearing none. Should we have Dan conduct the roll call vote? Sure. Okay, let's do it. We're all watching anyway, right? So. Oh.
Okay.
Let's.
Commissioner Miyasato moved to accept the evaluation and approve the bargaining unit 13 increase. Commissioner Bradshaw seconded. Commissioner Miyasato.
Aye.
Commissioner Bradshaw.
Aye.
Commissioner Kōʻele.
Aye.
Commissioner Kamake-Ohelo.
Aye.
Commissioner U.
Aye.
Chair Lee.
Aye.
Thank you, Chair. The motion passes unanimously.
Congratulations. I think Dan's buying lunch at some point in the near future. All right, we're at agenda item number 5, tentative meeting schedule. This next agenda item is the tentative meeting schedule. Mr. Odenker.
Thank you, Mr. Chair. On August 5th, we will be in Kona for DR 26-80, the Kona Animal Care matter. On August 19th, we will be once again on Maui for the Kuihelani Solar special permit, and also for Pūlama Lanai decision making. On September 10th, we will be on Kona for SP 90-374, which is Parker Ranch. On September 23rd, we will be on Maui again for the Pukalani Associates LLC motion for extension of time, and for the Pūlama Lanai adoption of order. On October 7th, we will be on Maui for the Ho'onani Development LLC final environmental impact statement acceptance. And in November, November 18th, we will be, oh no, that's already done. Okay, so that's it.
Okay, thank you. Commissioners, any questions on the tentative meeting schedule? All right, seeing none, this concludes our meeting. Is there any further business to discuss? Hearing none, this meeting is now adjourned. Thank you very much, everyone.